All right, stop the scroll. For the first time in years, Jon Gruden just scored a courtroom win against the NFL. Let me bring you into the drama. The Nevada Supreme Court just ruled that Gruden, the former Raiders coach, can keep his lawsuit public and avoid arbitration. That's a seismic shift for a case centered around leaked emails, a high-stakes legal battle, and the power dynamics within the NFL. And of course, the league didn't just sit back. They've already filed to appeal. So let's break it all down, paragraph by paragraph, and unpack why this ruling is huge, not just for Gruden, but potentially for anyone who's ever knuckled under forced arbitration clauses. Here's what happened. The Nevada Supreme Court, in a 5-2 decision, ruled that Jon Gruden's lawsuit can proceed in public court rather than being forced into arbitration, often seen as an insider-friendly, closed-door process. The court ruled that the NFL's arbitration clause is unconscionable for former employees like Gruden. It was a complete reversal of a prior 3-justice panel's decision from May 2024. Which had said the case must go to arbitration. Now the NFL has appealed for a rehearing, and if denied, this could head all the way to the U.S. Supreme Court. Gruden first filed the lawsuit in late 2021 after a set of emails he sent during his ESPN days. Emails containing sexist, racist, and homophobic language were leaked during an investigation into the Washington Commanders. He resigned as the Raiders coach shortly after the leak and claimed the NFL and Commissioner Roger Goodell orchestrated the leaks to damage his career. Now he's seeking monetary damages and saying the truth must come out. The arbitration clause at the heart of the case comes from the NFL Constitution, a document all league employees must follow. It gives the commissioner power to arbitrate conduct detrimental to the league. Previously, a lower court and a panel ruling said Gruden agreed to this when he signed his deal, making arbitration mandatory. But the full court disagreed, pointing to the unfairness of making a former employee arbitrate, especially when the commissioner named in the lawsuit could control the process. Justice Linda Marie Bell, who dissented in the 2024 panel, argued that the arbitration clause didn't apply to Gruden after he left the league, and it was unfairly binding. The newly expanded court seemed to side with that reasoning, also noting that the NFL Constitution's ability to be amended at will and without notice creates both procedural and substantive unconscionability, but those issues were overshadowed in their decision. It's important to point out, the court didn't rule on whether Gruden's claims are true. Instead, they ruled on jurisdiction and fairness. 2 judges on the previous panel ruled arbitration was valid, while the full court now says otherwise. This turn allows Gruden to pursue evidence, depositions, and testimony in open court, not a private arbitration route. That transparency could dramatically change how this plays out. Now, the NFL is pushing back. They've requested a rehearing from the same Nevada court, clearly banking on the possibility of overturning the decision. If that fails, the league may escalate all the way to the U.S. Supreme Court. The implications of each potential decision are massive, not only for this case, but for arbitration norms in employment contracts across all. Gruden's attorney, Adam Hosmer-Henner, applauded the ruling, calling it a victory not just for his client, but for anyone trapped by unfair employer arbitration clauses. He said it's about accountability and making sure organizations can't just sweep messy situations under the rug via arbitration. In contrast, the NFL hasn't issued any public comment following the decision, but their actions speak louder. They're fighting to maintain arbitration as a safeguard against public lawsuits. Arbitration has historically been criticized as biased in the employer's favor, and this ruling shines a spotlight on those concerns, especially when the arbitration overlord is the sub. This battle isn't just about Jon Gruden. It speaks to a growing question. How much power do employers have to force employees, current or former, into private, binding arbitration. If this case proceeds in court rather than arbitration, it could influence future litigation and contract negotiations across sports and beyond. Looking at Jon Gruden himself, he's no stranger to controversy or high-profile drama. He coached the Raiders, won a Super Bowl with the Buccaneers in 2003, and later took on analyst roles at ESPN and consultant gigs in arena football. His reputation has always polarized, and whether this lawsuit redeems it or exposes more fault lines remains to be seen. As fans or observers, what can we expect next? If the rehearing fails, the suit could go to trial. That means depositions, witnesses, and potentially explosive testimonies about internal NFL communications. It's rare to see the league in a courtroom spotlight like this, especially on arbitration's constitutionality. So that's the play-by-play. Gruden just got a big legal break. The NFL is appealing, and the arbitration issue might finally face real scrutiny. This case could set precedent for contract law, employment rights, and sports governance. No matter which side you take, it's a story with layers of intrigue, power, and courtroom drama. Let's watch how this unfolds and know that arbitration may never be the same again. As this legal showdown unfolds, many legal experts are watching closely, not just for the outcome, but for the ripple effects it may cause across all professional sports leagues. If Jon Gruden is allowed to move forward in open court, it could empower other current or former employees to challenge powerful organizations in public forums rather than being locked into private arbitration. That's a huge shift. Think about it. If the NFL, with its billions in revenue and ironclad contracts, can be challenged in court, it opens the door for coaches, players, and even front office staff in other leagues to push back when they feel wronged. The precedent could extend well beyond football, touching everything from corporate whistleblower cases to labor disputes in the entertainment industry. Meanwhile, Gruden has remained relatively quiet publicly, choosing not to make frequent media appearances or grandstanding statements. But in his few comments, he stayed consistent. He wants the full story to come out. "I want to make sure what happened to me doesn't happen to anyone else," he told ESPN. Whether you view him as a victim of targeted leaks or someone whose own words caught up with him, the legal process now has a chance to examine both sides in detail. For now, the ball's in the NFL's court, literally and figuratively. If they're granted a rehearing, this could drag out for months, even years. If not, get ready for one of the most high-profile legal battles professional sports has seen in a long time.